Oh, I'd be happy to. We need cups. No, there's cups. Oh, I didn't see them. Yep, they were hiding with your boots.
For you these days, no,
Yeah, came down with one. Well, with that one. Should be a decent class. Nothing. Plowed out to the woods. I want to get the right one. Social media,
You better skiing. You know.
Yeah.
Oh my gosh, yeah. It's a huge event. And inside of the forest right now. He doesn't take it out, you know, myself. Because I said, this is a young guy, how I sport.
that means only started.
You're doing.
That's right.
Okay. All them out, I feel bad for them.
All right,
Oh, I like that.
let's get started.
Christmas.
Welcome to the January meeting of the Commission on Governmental Ethics and Election Practices. We'll start right with agenda item 1, which is the ratification of minutes of the November 29th, 2023 meeting. Does anyone have a motion?
I'll make a motion to approve them as written.
Is there a second? Commissioner Hastings, okay. Is there any discussion?
Yes, page 2. Dealing with the Alpine and stuff before it.
Mm-hmm.
On the paragraph that begins prior to the meeting, the November 29th meeting. The identity of the client will be disclosed in the campaign finance report attached as Exhibit B to the stop the corridor consent agreement. But the other agreement did not identify the client, but at the meeting, the attorney for indicated that it was the same client, and I'd like the record to show that, the minutes to show that, because the other consent agreement does not identify the client.
I think that's very good.
Good point.
But it was made clear that it was the same client, and I think our minutes should reflect that.
I agree.
Amend my motion to reflect that.
Well, I think you're making a motion. You have some language.
I don't need language. That's what I wanted to do.
Trying to help you, David, sorry. Mr. Wayne, do you have language that might do that, or Mr. Bolton? Because I think that's a good idea.
Yeah, I think just perhaps a sentence just at the end of that paragraph.
Another sentence perhaps. At the
Yeah.
end of it. And that would have been in the Alpine Initiatives consent agreement.
Yep.
Could put a sentence at the end of that paragraph that although not stated in the Alpine Initiatives consent agreement,
The client referred to was the same.
client referred to is the same as identified in that Exhibit B.
Yeah, you could also add something to the end of the next paragraph, because I think it was Mr. McDonald that acknowledged that. So, so perhaps a sentence at the end of that paragraph,
That would
noting that, upon questioning, Mr. McDonald acknowledged.
That would be
that
fine.
was the same.
too.
Great, great. Is that your motion to amend?
Yeah, that was exactly right.
Is there a second to the motion to amend? Is there discussion on the motion to amend? Okay, we can have a voice vote. All in favor of the motion to amend, please say aye.
Aye.
All opposed, please say no. It passes unanimously. So we'll move to accept the minutes as amended. Is there a second?
Second.
Is there discussion? Okay, the motion is to accept the minutes as amended. All in favor, please say aye.
Aye.
All opposed, please say no. Passes unanimously. Great, thank you. That was a great change. Moving on to agenda item 2. This is the complaint by Mr. Clardy against Senator Jackson. And the normal way we do this and the way we'll do it today is we'll have Mr. Wayne kind of summarize the case in front of us, and then we'll give the parties a chance to address the commission. So, Mr. Wayne.
This is a complaint by Mr. William Clardy against State Senator Troy Jackson and the Freddie Clardy law firm. And Mr. Clardy is asking the commission to investigate 3 different issues. And the facts are that in 2020, Senator Jackson and his partner brought a lawsuit against the sellers of a property that Senator Jackson purchased. And he was alleging that the property had various defects that had not been disclosed. Initially, he tried to rescind the sale, but that didn't resolve itself, so a lawsuit was filed. And he was represented in these claims by the Freddie Clardy law firm. And about a month after the suit was filed in 2020, he entered into a contingent fee agreement with Freddie Clardy, and he agreed to pay them certain percentages of any amounts that were recovered from the defendants. So I always hesitate to summarize people's point of view, but from Mr. Clardy's perspective, Freddie Clardy has invested considerable resources in this lawsuit, and it's unclear whether they are going to receive adequate compensation because that's in the nature of contingent fee agreements. And he's asking the commission to investigate whether Senator Jackson should have reported his receipt of legal services as a gift in the annual statements of the sources of his income that he filed in 2020 and 2021 and 2022. Mr. Clardy is also asking the commission to investigate whether Freddie Clardy should have filed a report with our office because he's alleging Freddie Clardy may have made an expenditure to benefit Senator Jackson, giving rise to a reporting obligation. And then there's a third allegation, which the commission is required to consider in executive session. So that's discussed in a separate memo.
Very good. Any questions from commissioners for Mr. Wayne? Mr. Clardy, would you and anybody else who's a proponent care to address the commission?
Yes, sir.
And please start by introducing yourself and where you're from.
My name is, excuse me, William Clardy. I'm a resident of Augusta from the wrong side of the river. And as you folks probably have realized by now, I'm a big fan of transparency. And my complaint is primarily focused around reporting and maintaining that transparency. To me, that's really important, especially in a state where the government is dominated by a single party. The only way voters will have a clue as to who's in bed with who is through, what they can divine from who's supporting you. And this is where I'm actually a big fan of Maine and how y'all do it. I mean, you guys honestly do a good job of matching pragmatism with, coming up with good policy. But every once in a while, something comes up where, a blind spot becomes apparent. And that's what drives my complaint is the nature of the contingency fee agreement. It is, to me, it's an opportunity that without some policy, some guidelines, some sort of way to keep it honest is really ripe for abuse in terms of providing services for, we can adjust what you're going to pay, or what you're going to pay in the end is going to be indeterminate. So it makes it very hard to tell whether there's actually being favors traded or not. Now, I will preface this by saying I would have been severely disappointed if Senator Jackson had actually done anything as foolish as engaging in anything resembling a quid pro quo that, might look like it if you close one eye and squinted the other. I think he's smarter than that. I think he's better than that. I do think that he did not enter into this agreement with any intention of wrongdoing. But if you'll let me, I'd like to sort of diverge for a moment. I do software work, and one way we define specifications is what we call use cases. Because until you actually have an instance where, well, this is what happened, what do we want the system to do about it? Then you have a hard time defining, what you should expect. So this case, for my complaint, I'd like you to actually think of this as a use case of if Senator Jackson had been up to no good, or if Freddie Clardy was trying to peddle influence, how would we be able to detect that? What should we do? What guidelines could we offer? What guidance to legislators and elected officials could we offer that will help them steer clear of murky waters? So, reporting is really a big focus on this. The complaint is really more about reporting rather than any nefarious schemes. Starting from that, I know contingency agreements are common. And, they are a legitimate arrangement sanctioned by the Code of Ethics and prescribed for certain cases. They are most common in personal injury cases, at least that's my understanding. And it's where most often used where the client has what it is perceived as a winnable case, but may be challenged for some way to pay for the services upfront, and or winnable / profitable from the attorney's perspective. So in those instances, it makes sense for a firm. We're going to take a gamble that, yes, we will win the day for you for this, and we'll split the recovered amount at the end. Ironically, when I was actually looking into how common they are, almost impossible to tell because it's buried behind attorney-client privilege as far as going. But contingency cases actually, in most instances, create an incentive for the attorney to settle quickly for a minimal amount. Because, and this was something that kind of surprised me until I actually saw the math. If an attorney can get a $10,000 settlement for 2 billable hours of work, that's a much better return on investment for him than if he gets a $100,000 settlement after 40 hours of work. So with contingency cases, the longer it drags on, the worse it makes sense from a business perspective for the law firm. And that is something that makes this case a little bit anomalous as far as contingency, because it's been going on for, I think, 3-4 years now. And from my perception, or the way I look at it, a contingency case is basically a line of credit to the client. And it's may get paid off, may not, but that's up to the lawyer and ethics and all like that. So, but it is a line of credit, effectively, functionally. And it is, at some point in time, it does transition. Mr. Wayne, in his summation, or in his analysis memo, compared it to the normal billing practices of where, I hire an attorney, he sends me an invoice at the end of every month for how much he worked that month. I pay it. So it's deferred for, however long it takes for him to gather up the invoice and bill me. Somewhere between 1 month and 3 years, I think there is a transition between normal, I'm paying you as you go, to a line of credit. Where that line is, that would be a judgment matter. And I couldn't say for sure where the legislature would weigh in on that, or where y'all will weigh in on it. but I think it is different. You know, it changes the nature of the agreement from, you know, just I'm paying you for your services right now to line of credit. And that's where being a contingency fee agreement makes it hard to tell, you know, how much service is being provided, how much is actually being paid for it. And I think that is a policy level decision that, you know, I would strongly appreciate y'all taking into consideration, because one other thing I've learned from software development is when we hit a bug where the system doesn't process something right, after we hit the first one, there's always going to be a second and a third. So, you know, this is not just about Senator Jackson. This is about how do we address when the next one and the next one comes along, or is there anything to discourage it from coming along so that we keep the officials out of murky water? Anyway, a few things I would like to also add. The response by Freddie Flaherty actually was their response letter was a very sensible, in my mind, summation of the argument. They pegged it right off. You know, the complaint is basically about reporting, about transparency. I did kind of take exception to the tone where they were insinuating that I might have gotten a hold of the contingency fee agreement by some nefarious means. The public document was published in a news outlet. I also am amused that they took offense at, or took exception to my pointing out that they regularly engage in lobbying, because that word regularly was pulled straight off their website, where they said our team regularly works before the legislatures of each state. With regards to Senator Jackson's part in this, Senator Jackson expresses concern that your decision here may set a troubling precedent and may discourage or may make it harder for legislators to retain legal counsel. I would counter that with elected officials, actually government officials in general, you wind up giving up certain rights, certain privileges when you take office. I've worked in defense contracting and insurance fields for so long that I don't think I've had a year go by where I haven't had to go through multiple ethics briefings on, you know, if you give a gift over this much to anybody, you have to report it. And, you know, a friend who goes over to the government side, well, geez, that just changed whether or not I can host a birthday party for him. Stuff like that. It goes with the job. And because he's a public official, you know, that declaration, you know, that he made that he is for a transparent government actually should have meaning where instead of information coming out after the fact, you know, years after the fact, would have been better to actually address the issue up front. You know, as a as sort of a preemptive thing. I'm sure, you know, yeah, no, I don't think either party was sinister in their going into this agreement, but I also think neither party actually fully thought about the ramifications in terms of, well, what actually are we trading off here? And had they thought about it, it would have been good, in my opinion, had they reached out to your staff or asked the commission to weigh in, hey, is there any concern here? If there is, how should we handle it? better to do that ahead of time than after the fact. And the only other item I'd like to mention in relation to Senator Jackson, he mentioned that one of the attorneys testified against the bill, one of the bills that he sponsored that I mentioned. Public testimony is not what the concern or what my concern is here. My concern is more the reception. When the public finds out that, oh, you guys are cozy, how that reads, and the question implicit in that of what's going on when you're in attorney-client mode. You know, not the blatant, hey, here's this bill, will you sponsor it for us? So much, but the more subtle, hey, we're your people. So that it changes the perception later on when those same people are actually acting as lobbyists. It kind of presets an attitude. It's a fact of life. It's not anything inherently wrong, but it's something that it's part of the transparency thing, being aware of when it's going on. So as my final moment in this ramble, as you guys are discussing this, as you're thinking about this, think not just in terms of what did Senator Jackson do, what could he have done, what should he have done, what could or should, what do we think the law firm could or should have done, but also think in terms of what should we do, how can we address this so that instead of finding out 4 years after the fact, there's an encouragement to actually vet this ahead of time and make sure that there are safeguards in place to help ensure that the honest stay honest is really about it.
Thank you, Mr. Clardy. You raise a really interesting question. And to me, that question seems to be, because of the mechanics of a contingency fee agreement with an attorney, does that create a reporting problem for legislators? And there are important social and policy reasons for contingency fee agreements. As you mentioned, they allow people without the resources to pursue a lawsuit to initiate a lawsuit and have it followed through by an attorney without paying upfront for the services. So you think that legislators should be precluded from entering into contingency fee agreements?
I honestly am not sure if somebody can come up with a good way to actually, just raise a flag, and have somebody vet it. Okay, no, this shouldn't be a problem. And then monitor it. I think there should be a way to adjust reporting or, for reporting to take place so that, if it looks like it's an anomalous case, if something seems out of the norm, then it can get more of a review. Like I said, I'm more about transparency and reporting than prohibiting. But at the same time, discouraging them from entering into murky, bill bought out agreements. That's not exactly a bad idea in my book either.
How widely would you apply that prohibition? Would you apply it to the governor and the governor's cabinet and government employees generally?
I honestly, I'm not sure. I'm not sure I actually. I'm not sure I'm in a position to make a good statement on that. I think it would be relevant to how much power that person actually had, how much authority they had. The more authority you have, you know, the more practical the voter's view of your finances should be. So,
So there's a line somewhere, but
there's a line somewhere. You know, you guys deal with fuzzy lines all the time and you make judgment calls, which is part of what I like about Maine's processes. You don't draw a line in the sand and, oh, you stepped in and over that, you know, you're a horrible person. You know, you do take into consideration, was it deliberate? Was it an inadvertent? Was it a big step? How much did it impact voters' actual ability to tell what was going on? And that's why I'm emphasizing the whole use case thing of sure as, you know, cops go to donut shops, there's gonna be another one. There probably is some other legislator out there with a contingency, like the agreement right now, who may not realize that, oh, you know, I might want to actually let somebody know and, you know, make sure that everything stays on the up and up. So that, you know, somebody can't throw out a rabbit, well, he's taking money from so-and-so or he's in their pocket. And he'd actually be able to say, hey, look, you know, I talked to the ethics commission, I explained to them, they raised questions. You know, we're trying to be open about this. That's why with Senator Jackson, I mean, I took softball pitches on the facts I was presenting, kind of about akin to what I would think from, you know, if somebody asked to audit it or asked for an opinion on the situation.
thank you, Mr. Clark. Anybody else have any other commissioners in question? Commissioner Hastings?
A couple of questions. First, Clardy, I am curious, how did you come into possession of all the facts, like a copy of the contingency agreement
That
and?
was published on the Maine website as part of their articles on Senator Jackson's lawsuit.
Okay,
They obtained it from the court as part of the court documents.
it's interesting, because normally a contingency agreement would not be filed with the court, I wouldn't think, right?
Yeah, I realized that. I actually was a jurist on a trial where the decisive piece of evidence happened to be work product that was turned over during discovery. I found that out from one of the attorneys afterwards, because I was the one who was holding that in my hand when I'm like, oh, well, that set the date for that pretty clearly.
If I could, one other question, please. Is your concern about what legislators, let's say, engaging in contingency agreements apply if the attorney involved is not involved with a firm or personally in government relations or lobbying?
If
Applies to any case?
if it's not a firm or a lobbyist that is actually lobbying in the state of Maine, I wouldn't see a problem with it. I mean, I think that's, you know, it wouldn't, there wouldn't be any issue and you guys wouldn't even have any jurisdiction.
Well, but your concerns about a gift,
Yeah.
reporting and things like that, those would still exist, right?
Those would still exist, but they'd be, you know, they might be. Actually, yeah, you're right. They would be an issue from the legislator's perspective.
So you
As
think
far as-
that even a legislator dealing with an attorney that had nothing to do with lobbying, if he signed a contingent fee agreement, or she did, that they should consider whether or not they should report that as a gift?
I would,
And perhaps they should report it as a gift?
yeah, I would think that it would be worth at least, you know, running it past Ms. Burke or one of the staff members to say, you know, do you think this creates a reportable event?
Well,
If not,
along those lines, would that be true of any person in the legislature, for example, who engages with an attorney who, for whatever reason, gets a discount on their bill?
that one's a tough one. If they think they're getting the discount as a friend and family, or, you know, I like you as a legislator thing, technically, yes. But, again, very much a judgment call, and this is where, you know, I honestly, I don't see any way to flesh out everything here and now, but, where Mr. Wayne had suggested you guys vote, or you take no further action. At least getting started on addressing how should, where do you guys think those lines should be? Because you have much more experience with the politics and the people involved and how it would actually work out from your perspective with, what staff and how much work it would create for you. I don't have a clear answer to that, honestly.
Commissioner Marvel?
A lot of what you've offered, in my opinion, personally, is based on your interpretation of appearances of events and information. And at the risk of beating this sort of last series of questions to death, I just want to ask your opinion on a hypothetical. If someone in rural Maine successfully ran a grassroots campaign, and they happened to be someone of very low material means, and had a partner or a child subsequently hurt in a car accident and needed legal assistance through that process of medical care and everything else you can imagine. According to what you yourself said, it seems to me logical that a contingency arrangement would make sense in that case. But they're an elected official, and so as the result of a car accident involving a family member or someone elected to the legislature who then found the only way they could get legal representation was through a contingency agreement, that they should somehow be further analyzed? That some sort of flag should be raised?
As a legislator, that they do have an obligation to be open about, who if they're accepting gifts from, and if a contingency fee agreement is taking place over a long enough period of time to qualify as a gift, then it would create a reporting requirement. Not saying.
But isn't
that they
it
should be barred
frequently
from
the
it.
case that the length of time said agreement is in place is at least partly determined by the other party?
It is.
If I'm involved in something and the other party is refusing to settle, or however you want to phrase that, I'm not in control of the length of that arrangement.
No, you're not. But that's where, even though you're not in control of it, it's an ongoing transaction. If the attorney is still providing additional services, aggressively pursuing the case, they're providing those services on a line of credit.
That has nothing to do with the legislative responsibilities of the person.
Does not, unfortunately, as far as I'm aware, the reporting requirements don't specify that the gifts have to be from lobbyists, and that's where there may be some policy and fine tuning.
So you're defining that as a gift.
It would be a gift in terms of being something of value. It's statutorily, I believe that a line of credit or a loan or the forgiveness of a loan does come under the definition for that. If I'm mistaken, please correct me.
How about a case where a legislator enters into a non-legal kind of contract, like a legislator hires a paving company to pave his driveway and isn't required to pay until the end of the contract? Would you consider that a gift as well?
It depends. When I do contracting or get a contractor, I put down a down payment and the rest is due upon completion. And again,
And the job will be completed before the payment's made.
and the job will be completed. How long after that you pay? That's where, like I said, somewhere between that, monthly invoice that you pay within 30 days and 4 years, it changes. Does it change when you have that open obligation for a year, 2 years? I don't know, but I do think the passage of time changes it. or changes the significance of it.
That would be a pretty sweeping, policy to adopt.
That's where, I mean, it could be a potentially very sweeping policy. It could be a potentially very narrowly constrained one. And I think, in all honesty, addressing the time aspect of it. The gift reporting is a once a year event. If something is ongoing for a year, that's kind of exceptional in terms of legal cases, I think, even post-COVID. 2 years definitely would be exceptional, I think. Except when it's getting really long and drawn out. But those would be, again, because if you can filter for the 90% that are perfectly normal and just get reporting on the ones that are far enough out of norm to be a concern, and just look at them, let us see, or if it's proprietary information, the staff or whoever, look and see if there's anything to be concerned about. But it is something where at some point, somebody else should take a look at it.
Does anybody else, any other commissioners have questions? Commissioner?
I'm just a little confused. You're calling a contingency fee agreement a line of credit, basically, you're assessing it.
Basically, it functions as that.
Okay. So it's something of value that's given. But the contingent fee agreement, if the case is unsuccessful, there's no payment due. Then that's the contract between the attorney and the client.
That is.
It's
And
not
then
like
the question becomes, how much value did the question would become, how much value did the attorney provide in exchange for no payment?
So are you saying that there's a thing of value that's given, even if there's a loss and there's no value to the firm that's obtained because they didn't win? There's no value to the client because they didn't win. There's losses and fees and things like that. You're saying that's some sort of income to somebody?
It is, the services are by definition a thing of value. But
The win is the thing of value.
the win is the thing of value to both the attorney and the client. Or that's the primary thing of value. Having the legal representation, especially if in Chairman Streiner's case, or I'm sorry, I'm confusing who was positing the case.
No worries.
For the guy from up north who had no money and needed legal representation, those services also are important in terms of trying to make things right. That is something of value in and of itself. I don't honestly see a way that could, or I think that's an area in the case where there was no win, there was no compensation paid. The actual value of the services provided may be beyond your reach to ever see. Based on, as Freddie Clardy pointed out, attorney-client privilege and those aspects. I think as a practical matter, that's something where there's no practical way to address that portion of it.
So, I mean, contingency fee agreements are a long-standing tradition in the legal
Yes.
profession. They absolutely allow people, working class folks, poor people, who don't have any means to obtain legal representation other than that for a grievous wrong, such as a car accident or medical malpractice or whatever. And are you saying that our citizen legislators should be denied that right? That it should be, that it should be considered some sort of income?
That's why as I said earlier, I'm really hesitant to say deny. But I do think that if they are entering into an agreement like that where, it could, if it was a line of credit, from any other type of entity, that it would generate a reporting obligation, if they got a sub rate mortgage from, the local bank. Because, hey, I know you're a legislator, you're a good guy, we like what you're doing. We'll knock a percentage point off your mortgage. That kind of thing, I think you could conceptually see that as being, that's pretty much a gift. Contingency fees also in that sense could be. And I'm not saying, honestly, I'm not saying bar them, but at least let people be aware, if they are in existence, and especially be aware if they involve, identified registered lobbying firms. Or well, actually I don't think there are any registered lobbying firms, because that's actually a little bit of a gap in the law.
Well, they're required to file reports of lobbying.
Actually, I think all the reporting is done on the individual level, isn't it? That was one thing that I was actually kind of puzzled by, honestly.
The lobbyist files the report, but the good news for Mr. Clardy is we have a new public disclosure website coming, and each lobbying firm will have its own profile page. So they'll be highlighted a little bit more, but technically it's the lobbyist who does.
Yeah, terrific. Any other questions for Mr. Clardy from commissioners? Thank you, Mr. Clardy. We appreciate it. And it really is, it's a novel question. Thank you. Mr. Senator Jackson, you want to bring your team up or you can appear by yourself. It's up to you.
Thank you. I'm the Maine Ethics Commission. I am Troy Jackson, State Senator from District 1 in Allagash, and I have the privilege of serving as Senate President. I think the letter, the response that I filed to the complaint is pretty much, my whole argument. It's not a gift. I didn't receive a gift. I never considered it a gift to file the complaint. I think you would all understand it better than I would. I would imagine that lawyers sometimes look at a case that somebody brings to them and decides if it's winnable, decides all these different things, and then goes forward saying that they'll do a contingency agreement. In my time, I've had 3 of these, and all 3 of them were exactly the same as far as the contingency aspect of it. I think the people that took the cases on thought that there was a good shot of winning, so that's probably why. But I've certainly had issues in the logging industry where people didn't think that I was going to be able to win, and they probably thought I was right, but they didn't think they were going to be able to win, and certainly so they didn't. But in this case, it is absolutely not a gift. I got a small settlement of $12,000. Freddie took their third, and that's what was going to happen if and when we win the other portion of the case. And I would just say, like, on the time aspect, the 2 I had before were almost the same time, and that was not with COVID in the middle of it. And we did, COVID happened right about the time we filed, which slowed the courts all down, stuff like that. So, but even if it had been a year or 5 years, I still wouldn't have thought to make this as a gift, because I don't believe it's a gift. We paid for services, and we will pay if we end up winning, the overall case. And I guess I just want to finish with, like, I take this stuff very seriously. my moral obligation, my ethics, you know, they have certainly been questioned a lot more as I've rose. You know, in the positions I'm in, but this is something that I think about a lot. I think about the people that elect me, I think about the people in the state and, you know, their perception and stuff like that. And I, you know, I'm very conscious of that. So I think this is, you know, something that my response, I just disagree with it. I think it's not a gift and therefore it wasn't something that should have been reported.
Thank you. Were you wanting to say something? Okay, sorry. Any commissioners, interested in? Yes, Commissioner Hastings.
Senator Jackson, I understand that you would want a contingent fee agreement to proceed with this. I guess if I have any concern, it's that you did it with a very prominent lobbying firm, which spends a lot of time in the State House trying to influence legislation. So it's that appearance that I wonder if you could have got that a contingency fee agreement with somebody else, or if somehow Freddie was giving you because of your position. I do see there's some appearance of possibility of, at least to an outsider, saying, well, maybe Senator Jackson got a sweetheart deal from Freddie Clardy because they wanted to be on his good side, wanted to gain some influence with him. It's that appearance that concerns me. Not that there's anything wrong with contingency fee agreements at all. And I don't, did you go to anybody else besides Freddie Flaherty to see if you could get a contingency fee? I mean, the agreements are all signed by, you know, Severin Beliveau, who was their premier lobbyist. It all looks just a little unusual to me. But I don't know why you went to Freddie Flaherty. There are plenty of other lawyers around in Augusta. So that's just, it's that appearance of raises an issue with me, not that there's anything actually wrong, but
Like I said, this is the third one of these that I've had, the other two in Mercer County. In Mercer County, I went to people that I knew. The first one was Attorney David Susi, who was a judge, became a judge. He took it on. The second one was actually former Representative William Smith, someone that I knew that I'd served in the legislature with. And in this case, down here in Kennebec County, so you know lawyers, but I don't really, I mean, most of the lawyers I know are at the legislature. I mean, that's just the reality of it. I mean, and so when we had this happen, it was financially very, very concerning for me and my wife / partner. And so that's why I reached out to Severin. Now, the attorney that I dealt with, Mr. Warner, at the time was not registered to lobby at all. And again, I didn't see any of this as, you know, getting an advantage. Mr. Warner actually was against me on the Veterans Home bill. That was a big deal for me. Mr. Warner was on the residency requirement bill for marijuana people, that they didn't have to be in state, which I think both of you know how much I've pushed for Maine people to have, you know, the opportunities. So, I mean, I've been on the other side of Freddie Flaherty more often. As a matter of fact, the case that Attorney Susi took on, Freddie Flaherty was on the other side of that case. So, I mean, some of you served, some of you haven't, but I mean, I know all kinds of people, they're Republicans and Democrats, that I can separate the issue from my personal relationship with them or anything like that, and I do that all the time. You know, and as far as, I mean, there's other people that come before you. There are lobbyists over there that represent people all the time in the legislature, and that doesn't seem to be called out. But this, as Mr. Clardy said, was in the Maine wire. This is something that is funded unfortunately by the Republican Party. And, you know, that's how this all came to be. Now, perception, I can't help that. But I know point blank in my heart that Perry Flaherty never received any benefit from taking me on this case. And there's vote after vote after vote that shows it, including the ones that Mr. Clardy listed.
Any other questions from commissioners? Thank you,
Thank you, appreciate it.
Does anybody want to make a motion?
And move that no further investigation be taken.
Okay,
Second.
is there a second? And that's on the two questions, the
Yeah.
first two of the
First
three
two.
questions.
Correct, yeah.
You move, most, excuse me, most,
No
I
further
move that no
action.
further action.
okay.
And was there a second?
Yes.
Okay. Is there discussion? I mean, I'll start it off. I think for a lot of, mostly policy reasons, I think it's important that legislators and public servants are able to take advantage of a long-standing arrangement that allows them to be represented in legal issues in the contingency agreement. I think I would not want to make a decision that would preclude or even limit a legislator's ability to get legal representation through a contingency agreement. So I support the motion.
I agree, and I also note, to Mr. Clardy's, he talked a lot about transparency, and I believe he's not trying to say limit, but the way a lot of attorney fee agreements go is they're often not public. They can be resolved before they're public. The settlement agreements are confidential and required to be, and so you would, even a transparency or some kind of reporting requirement would severely limit people's
Right.
ability to take these cases on because of that nature.
Right.
So yeah.
And I'd like to echo Commissioner Hastings' comment, though. I think, Senator Jackson, you could have maybe avoided all this and avoided an appearance of impropriety, even the hint of an appearance of impropriety, maybe by a law firm that wasn't camped out at the State House all the time. And I think that, that I don't think you did anything wrong, but I think, maybe you could have avoided the whole appearance or even a hint of appearance by finding a law firm that wasn't so actively involved in law.
I do, one thing I have a little concern with, is reading, I guess Attorney Petroselli's letter. It sounds like there's had to be a recusal because of this
It's,
allegation.
he's saying that they're.
And, that's a real concern to me.
Yeah.
And I think that's something that we as a commission might consider, sort of, someone makes an allegation and it triggers this. And that could really be used to manipulate litigation, and it's having an effect here. And so that's something that is maybe tangential, but I think really important. I don't want this commission to be weaponized.
Yeah, people should not take lightly the idea of making a complaint. I mean, it's, in this case, it's a complaint that raises a novel issue that I think it's not bad for us to consider, but there are serious consequences of having made that complaint. And one of them is that Senator Jackson may have to find a new law firm to represent him. And that will at least delay, certainly delay whatever relief he's looking for, and could have other difficulties as well. So I think that's a great point. Other Commissioner Hassan?
My comment is that I find no fault with Senator Jackson's conduct.
No, I don't know.
But I know the complaint was also made against Freddie Flaherty, so that is still out there.
Well, but he's claiming that they should have reported,
Well, I
gift.
believe Mr.
Well, you haven't, that's an allegation, that's a requested investigation. There hasn't been a lot of discussion of that. But the motion is not to take any action on that one either based on the discussion.
right?
Yeah, my motion was for both.
I just have a little more concern about Freddie Flaherty's conduct. I mean, did they enter into it? And I know it's not before us right now. Maybe it is before us.
It is
It's not
before
quite
us.
clear.
It's absolutely before.
Did Freddie Flaherty offer a legislator very good, a deal that they would not have offered anyone else.
Is there anybody here who could address that?
And, that concerns me a bit. The agreement is made with the chief lobbyist essentially of Freddie Clardy.
Mhm.
But man, but I'm sure Freddie Clardy's, the government relations department would like to be on good terms with President of the Senate. I would.
Sorry, I didn't see you, Mr. Petrocelli.
So I have more concern almost from that side.
Sure. If you'd like to introduce yourself and address Commissioner Hastings' question.
Charlotte Petrocelli, Martin Haddo, attorney representing Freddie Clardy and any lawyer at Freddie Clardy who's in the crosshairs here. The answer to your question, Mr. Hastings, is no. That this case started out as a six-figure demand for money for fraud. And such cases, as you know from your long experience, are fortunately in Maine, we don't have them every day because Maine people still don't commit fraud every day. But when they do, the kind of relief that the person who feels defrauded is entitled to in the first instance is a large amount of money, and this on the math makes perfect sense as a contingent fee arrangement. And I certainly think it's not a surprise that people go to lawyers they know. And you may be right that there are plenty of other lawyers around, but you also must know that there's a process whereby people find their way to lawyers and they don't go and interview everybody in town and make some kind of choice. They go where they know. And there's absolutely nothing irregular about anything here at Freddie Clardy's orbit. And I think it's important to observe that the only, much of what happened here with Mr. Clardy at this table struck me as a kind of a brainstorming session of a rulemaking group about whether there ought to be some different rules than the ones we have. And I would like to suggest that I have only here the responsibility of resisting the idea that there was ever a moment that Freddie Clardy had a reporting obligation under any of the current laws as they're currently written and not as envisioned by Mr. Clardy for some future situation. And I think there is absolutely no doubt that there has never been a reportable event, and there has therefore been no failure to report. And that is the only issue that involves Freddie Clardy within the purview of this commission. And concerns about appearances and maybe Freddie Clardy ought to reconsider its public relations are not before us. And I would also respectfully suggest, although I'm sure you all know this, that this commission's mandate does not involve the governance of lawyers. And lawyers are constrained by rules of confidentiality, which go far beyond the attorney-client privilege, and they are not at liberty to report to you everything that they do for their clients. And if there's a reporting obligation about making a contingent fee agreement, it's going to be a very difficult one to write or construe or enforce. And that is why everything that you know about the partial settlement of this case has come to you from Senator Jackson, because he's the client and he's at liberty to tell you. The lawyers are not, and the lawyers ought not to be criticized or punished for failing to disclose things which they are duty bound not to disclose. And we think that the motion is well grounded, and we hope you will all support it.
Any questions for Mr. Petrocelli from commissioners?
Just, I mean, in the idea of confidentiality, I mean, there are certain areas of law where disclosing that sort of thing would not be permitted. I mean, I'm thinking in human rights complaint that hasn't gone public. You could disclose without harming your case.
Absolutely. There are other supervening requirements in specific cases, and I was only referring to the general obligation to preserve confidences and secrets of clients well beyond the scope of attorney-client privilege, which is just a rule of evidence law.
Part of legal practice is you may have cases that people don't want to go public.
Right.
Correct, and that's a negotiating advantage. We have not gone public with this yet. We won't go public with it if we settle it now. So that would be a barrier
Indeed, I've mediated many cases pre anything, and a large part of the issue is, we would all rather nobody know we're doing this. And so it might be an intersection of the political reporting rules and a lot of other rules, and, I suppose there can be differences of opinion about which ought to prevail, but this is not a policymaking session. All I know is that nobody violated any reporting obligation, and I'm staying in my lane.
And I just to, you know, put a, I guess, fine point on it, there's been a lot of talk of contingencies and personal injuries. There's a myriad of other types of cases in the law that do contingency fee agreements.
Anytime there's an amount of money at stake, for whatever the reason, that the contingent fee agreement is in play, even sometimes for very wealthy people who are very prudent with how they spend their money, and they don't want to pay unless they win. And so it is not at all uncommon for a contingent fee. The point is that there are more car crashes than there are frauds, and somebody can tell those two facts, sorry, everybody, those two facts and find an anomaly. But there's no anomaly, it's just the statistical likelihood of people crashing a car against the statistical likelihood of somebody getting defrauded.
Any other questions?
Just one other discussion, kind of beat this to death, but in a case such as a malpractice case or something that's taken on contingency, a law firm may spend $100,000 more hiring experts and stuff, but still come up short. Is not considered income or a line of credit or gift to the client in the unsuccessful case.
No, I understand there's been a lot of, in the history of this wrestling with the rules about what lawyers may or may not do on behalf of their clients. But advancing expenditures is permissible under the rules that govern lawyers. And if they're going to be prohibited under the rules that govern lawyers who are associated with other lawyers who come to the legislature, seems to me there's going to have to be some new legislation, and maybe we'll go back before whatever committee in the legislature is going to write that rule. But I'm back to saying it's a very complicated common practice, as you suggest with your question. And all I know is that there was no reporting violation in this case.
And those expenses are usually reimbursed at the end of the case by the client, right?
Absolutely.
Right. Any other questions for Mr. Frederick? Thank you very much, sir.
Thank you. Find my pen now.
It didn't run too far.
I hope you weren't throwing at us in anger.
No, I'm a clumsy person.
Senator Jackson.
Yeah. Like Chad to respond to that.
Okay.
I just wanted to be clear because I think that puts more of an onus on legislators, what we brought up. But I mean, we have a system here where, Kate Knox, emergency insurer, represents the Democratic Party. If there's an ethics violation or something like that, she comes. Josh Tardy represents the Republican Party. If they have an ethics violation, he represents them. They're both registered lobbyists. I mean, if you're gonna go down that road, I mean, that seems like that could be considered a gift. I mean, I paid for my services, although not to the probably full extent at this point. But I don't really see how it can be any different in that regard there. I mean, those are major firms that have lobbyists, they represent legislators, everyone accepts that, I accept that. Cause I know that Josh and Kate are both great people and wouldn't ask for any benefit because they represent them. Much the same way that Pretty Flaherty never asked me for any benefit. In fact, at the very same time, I was against them on numerous things, so I just want to make sure that is clear, that neither I nor Pretty benefited from a case that I wish I never would have had to deal with.
Thank you. Any questions for Senator Jackson? No. Okay, we have a motion and a second, and we're discussing the issue. Watch out. Everybody's throwing things today. Is there further discussion?
Knowing no bounds sometimes, I want to throw something I hope is related out that makes some sense. I've been reflecting, listening to this morning. Not quite having the perspective of a lot of people on either side of me. And I've been impressed and I've been educated by all of this, and that may comment the use of time that's almost a detriment to others. Senator, you have other things to do. But I think discussions like this can be very valuable and very valuable for the public. And the only thing I want to add is this. We're living in a day and age in which we don't seem to be able to anchor on someone like a Walter Cronkite. And the lengths to which some elected officials nationally are being the subjects of sometimes completely illegitimate accusations. And I'm not saying that's what's going on here, but there's a range. And what I want to point to is this. I just hope that the public stays involved, stays engaged, and pays attention, but when they're looking at source information, they take responsibility on themselves to try to make sure that that information is coming from as objective and reputable a set of sources as they can. My fellow commissioner to the left mentioned she didn't want to see the commission being weaponized. And I think what I'm trying to say, not as clearly as I'd like to, is along similar lines. There's a place to hold up practices that are public, that represent other people, the light of day for everybody. And there are other times where we have to be careful we're not going on assumptions or appearances that are not objective. And I just want all of us to try to find that balance as best we can in what we do.
Thank you. Any other discussion from commissioners? Okay, we've reached the time for a vote. The motion is to take no further action on the first two questions. All in favor of taking no further action, please say aye.
Aye.
All opposed, please say no. It's unanimous. We'll take no further action on the first two parts of the complaint. So we've come to the time when we need to move into executive session. And I'm going to do that now. Pursuant to Title I of the Maine Revised Statute, Section 4054, I move that we go into executive session pursuant to Title I, Section 1013, Paragraph 3A, to discuss whether to pursue a legislative ethics complaint. Is there a second?
Second.
Is there discussion? Okay, we'll move to a vote. All in favor, please say aye.
Aye.
All opposed, please say no. Okay, we'll go into executive session. I'd ask everyone to clear the room. I would ask Mr. Clardy and Senator Jackson and your attorneys to stay nearby. We may want to hear.
Excuse me.
Yeah.
May we, the Freddie group? be
I think you can leave.
Thank you very much.
Thank you for your help.
Thank you.
Yeah, I have files in these 71 page.
Oh my God.
Position is the motion.
Okay, I'll note that the public is back and the parties are back in the room. I would like to move first to come out of executive session.
Second.
Is there any discussion? We'll go to a vote. All in favor of coming out of executive session, please say aye.
Aye.
All opposed, please say no. Okay, we're out of executive session. We're back in public session. I think we're transmitting again. Would anybody like to make a motion on the proposed legislative ethics committee?
I move that we take no further action.
Is there a second?
Second.
Is there discussion? It's been moved and seconded that we take no further action on the legislative ethics complaint. All in favor of taking no further action, please say aye.
Aye.
All opposed, please say no. Okay. Thank you very much, folks. We appreciate your presence and your help getting through this.
Thank you very much. Appreciate the discussion and, it's okay. It's okay. I'm gonna come back next time.
I encourage
You
it.
do not have to.
Well, It may be midsummer though, so.
That's right, that's good, that's true.
Thank you.
If you want to wear a midsummer, you wear a midsummer.
Yeah,
I do wear them.
You wear these a lot.
Okay, let's move on to agenda item 3, which is a late major contributor report from Genuine Parts Company. Are we anticipating somebody on Zoom?
Yes, I've asked her to join. I'm gonna have Emma text her.
Okay. Is there anybody else here on this question?
Emma is participating via Zoom as well.
Okay. There's Emma.
Hello. Julie, what did you want me to do with?
I didn't know if you had a way to communicate with Kathleen about joining us. I've requested her to join the main session. She has not.
Okay. I will email her real quick.
Yeah.
Is she in a waiting room?
She is in the breakout room.
Okay.
We're just gonna leave the door open in case members of the public want to come in.
Thanks.
Is she in a breakout?
Like the green room.
Right.
But that's when you open the door and walk in and say something.
I could,
How to do it.
by naming it something similar, I think it would make it more complex.
I want to echo.
I do not. I'll ask her. Okay.
I have sent her an email. It's also sometimes those invites to join don't show up very well.
Do you happen to have her phone number?
Let me look.
You can email it to us and we can call her here if you'd like.
If I went back to the Irish, sounds like that. Wow. Yeah, I'm sure that was a good decision. You know, he was not gonna hand his village princess. Yeah.
Oh, she just emailed me back. Hold on. She said that she's in the breakout room reading and she has not seen anything.
All right, if she wants to maybe exit and rejoin, I can just keep her right, oh, I see that she's here.
Yeah, there we go.
Thank you.
Okay, good morning.
Good morning. Could you pronounce your name for us?
Sure, it's Kathleen Idebo. It's a hard last name.
No, it's just, we need to hear it once.
Sure.
So our procedure here is normally that we will hear from Mr. Wayne, the executive director, and he'll kind of give us the background and what's going on. And then we'll give you a chance to address the commission.
Very good.
Mr. Wayne?
So this is the matter of a major contributor report being filed 1 day late with the commission. The way the requirement works, if a source gives more than $100,000 to a ballot question committee to support or oppose a ballot question, then the ballot question committee receiving the contribution is supposed to send a notice to the contributor And then at the next regular filing deadline for ballot question committees, the contributor is supposed to file a major contributor report with the commission. So on September 1st, Genuine Auto Parts donated $500,000 to the Maine Automotive Right to Repair Ballot Question Committee to support question 4. And the BQC was late in sending a notice to Genuine Auto Parts. My understanding is that the BQC sent the notice to the contributor on September 27th. Although I'm not sure if it was received and read right away, there were some communication gaps in the situation. So, but after Genuine Auto Parts received that notice, it should have filed its major contributor report with our department on October 5th, but it filed it 1 day late on October 6th. So the preliminary penalty is $50,000, which is 10% of the contribution. Staff is recommending a reduction to 5,000, which we discussed at the last meeting. We proposed as sort of a new baseline, but to our recommendations, we might go up or down from that depending on the diligence and the circumstances.
Great. Are there questions for Mr. Wayne about this? Okay, terrific. Are you representing, what is it? Genuine Auto Parts?
Yes, I'm Kathleen Idebo. I'm the Vice President of Legal for Genuine Parts Company. And I will just put a plug in that the president of Genuine Parts Company, Will Stingle, actually grew up in Maine, and we were talking about this yesterday. So I'm really hoping that I can go back to him with some good news of what happened in Maine. So, I have no disagreement with the facts that were laid out. There are some extenuating circumstances here that resulted in the report being filed a day late. First of all, I've been with the company for 26 years, and we are a very non-political company. This is the first time I've ever heard of Genuine Parts Company making a donation to a lobbying organization. Obviously, the right to repair is very important to our company, that consumers have the right to choose they can get their vehicle fixed. But Genuine Parts Company is very non-political, and the legal department was actually not aware of the donation being made. So we didn't know that the report needed to be filed. And we learned of it when the fine came in. So the individual at Genuine Parts Company who facilitated this donation, Kevin Heron, actually retired a few days after the donation was made, or the contribution was made. So his email was not being monitored for this report form that was sent by the Auto Care Association of Maine. So finally, I believe the day the report was supposed to be filed, somebody from Auto Care Association of Maine got with somebody at Genuine Parts. Again, the legal department was still not involved, which somebody should have gotten us involved. From our team, that's an internal problem, but just so you know, finally did get the form filed, and I just learned actually a couple days ago that they claim that our folks internally said they did file it timely, but it wasn't signed. So we did file it a day late, a signed copy. So I was just here to ask that, there was no actual harm to Maine voters with the report being filed a day late. There was no intent on the part of the company to skirt this requirement. And that, I'm just asking respectfully that the fine be completely eliminated. We're a distributor of products, and as such, we have to sell a lot of filters to even make $5,000. So I would just ask that the fine be eliminated.
Thank you very much. Are there questions for Ms. Idebo? Sorry. Commissioners have any questions? Okay, terrific. Ma'am, you're not here on this issue, are you?
Me? Oh, no, sorry.
Okay. Okay, so is there a motion? I'll make a motion that we, reduce the penalty to $5,000.
I'll second that.
Okay, discussion. To me, it makes sense to reduce the penalty. I think the fact that it was only one day late and it seems like it was filed but unsigned on the day that it was due. I think that really minimizes the effect on the public of not knowing this information. So I think it's justified, we're justified in reducing the fine to $5,000.
I want to echo what you're citing. And it's not, Kathleen, what you were looking forward to sharing for news, but I think you can say that those mitigating factors did reduce it by a 90% factor down to the staff recommended level. So I'm in agreement. I support the motion.
Are there other
You know,
comments or discussion? Commissioner Hayes?
I just point out that it may seem like a lot for being one day late, but this is spending $500,000 to
Right.
influence Maine voters, and I think we do require pretty strict compliance with our reporting rules in this. And so I'm fine with the 5,000, but it's not a real if this was a $500, a smaller donation, that would be another thing.
Right. Right.
I agree
Okay.
with everything said.
It's been moved and seconded to reduce the fine to $5,000. All in favor, please say aye. Aye. All opposed, please say no. It's unanimous. Ms. Ibo, thank you for appearing and helping us work through this.
Thank you very much.
And I think you can let your boss know that it was a successful result.
Okay, thank you so much.
That's that.
Thank you. Okay, agenda item 4, we're going to postpone to give these folks an opportunity to appear. Agenda item 5 is the adoption of rule amendments. We didn't hear from anybody. Jonathan, do you want to discuss this?
Sure, this was a rulemaking that the commission initiated on October 25th. Most of the amendments reflect statutory changes in the state law, and so we have to implement those or modify our rules accordingly. We invited comment. We didn't receive any written comments. We did have one advocacy group show up and
Supportive comments.
yeah, supportive comments.
Yeah.
So, given that we only received supportive comments, staff recommends adopting the amendments that were put out in October.
Mr. Bolton, do we need to go one by one or can we just adopt?
No,
this?
you can adopt you can have one motion to adopt the full package.
Okay, I'll make that motion. Is there a second? Okay, great. Is there discussion? We've worked through these pretty thoroughly.
Yeah, I think
Okay, we'll move on to a vote. All in favor of adopting these rule amendments, please say aye.
I,
All opposed, please say no. It's unanimous. Great, moving on to agenda item 6, proposed rulemaking on spending by foreign government influenced entities. Jonathan?
So in the November election from last year, Maine voters approved question 2, which is intended to prevent foreign governments from making contributions or making expenditures to influence candidate elections in Maine or ballot question elections in Maine. And the staff conferred with our council on proposed amendments to implement the new law. And we drafted some amendments for your consideration, which were included in the packet. So once you feel comfortable with these rules, proposed amendments, our suggestion would be to initiate a rulemaking, which means you would be inviting public comment. You would receive written comments and hold a public hearing at your next meeting.
Terrific.
And the amendments are summarized in the packet.
Terrific.
We could answer any questions you have about it.
Great, thank you. I appreciate it.
can I ask a general question?
You may.
I know that there's some litigation with respect to this initiative. Can you just sort of tell us procedurally with timing, how that might relate?
Yeah,
That's what we should know about it.
Sure, I don't think they're really totally connected. I mean, right, there is litigation claiming this entire law is unconstitutional and should be struck down. And so that's in the preliminary injunction stage right now. So we expect by the end of February, we'll know whether the law is going to be enjoined. And if the law were enjoined, presumably any rules that went into effect would be also be subject to that injunction. But there's nothing that stops the commission from adopting the rules. So, if there's not an injunction, or if there's an injunction and it's later lifted, everything's sort of ready to go, into effect. So that's the idea. Is there's, the statute requires the commission to, rulemaking is mandatory under the statute. And so, until a court tells us we're not allowed to comply with the statute, which hopefully it won't do, the idea is to go ahead and go through the rulemaking process.
Great, thank you. My only comment on the rules, is that the potential penalty seems really way too small. We're proposing a maximum of $100 fine for a media company that knowingly accepts a foreign payment for advertising.
It's actually, if it's not known, the $100 is if there's no finding that it's knowing. So
That's knowingly violated. Yeah,
Statute says up to 5,000.
right, in the enforcement, you're talking
oh,
about
I'm
section
sorry,
G.
unless there was a fine, okay, so.
The statute has a
Up to-
cap of a $5,000.
Got it.
Statute.
And this is only if it's not known.
The idea, and this is obviously your call, not staff's or mine, but the idea was to allow for, given that there might be media, given that this is different than normal ethics commission regulation, it regulates entities that we don't normally regulate. The idea would be to have a more lenient approach for first violation where it's unknowing, the entity doesn't know they're supposed to have a policy. And then there's a presumption that kicks in that if they violate the statute again, then the full $5,000 is potentially, on the table at that point. So that's the idea behind it. But again, it's up to you all.
I don't know. I mean, $100 still seems so low.
Yeah, it's like cost of doing business,
Right, and just to not, that means, knowingly is a high standard as it should be, but I think what we're trying to get is for people to learn the law, do a little diligence.
It doesn't say
I
pay
hate
attention, does
for
it?
regular folks who put a sign in their yard to
Yeah,
have a higher fine
yeah,
than a media
Good point.
company.
yeah.
I don't
Can
know.
I ask a question? So we're getting into the press and, radio and TV stations and stuff like that. And we do that already when we say the disclaimers on the ends of ads and bottoms of ads, right? Well, how,
I don't know that applies to the press, right?
We rarely, in fact, I don't think we, in my experience, have ever penalized a newspaper or broadcast station.
we go after the,
We go after the party that's responsible for it. There actually is, I think, a provision in the section 1014 that says they are legally, it does place
And what-
some restrictions on them.
and what
but
is the
we-
penalty? I mean, even if we haven't done it, what is the penalty, you know?
I think it's the same. It's probably the same as applies to the sponsor of the ad, which is it's a discretionary amount. But John's actually looking at statute, so he can confirm this, but I think it's a discretionary amount up to the amount of the expenditure. I think that same penalty.
Is it more than $100?
It could be.
Yeah, it could be. And it's a provision in 1014, as Jonathan says, and it says, it has to do with these ads that require disclosures. And it says, no person operating a broadcast station or cable television system within the state may broadcast any communication as described in the statute without an oral or written visual announcement of the disclosure requirement of the section. And then it's just subject to the normal penalty requirements that apply to any violator of this section of the statute.
So just to put it in
Well, that's
regular
just
person
broadcast.
speak, that's the little font at the bottom of that ad.
Yeah, that's exactly right. Yeah. So that is one, it might be the only example. But it's one example where the commission does have a rule that affects broadcast.
And that's just broadcasting, radio, television, it doesn't apply to print.
Correct.
That's,
It doesn't apply to newspapers?
They're two different
Maybe there's a
subsections.
different
There
one.
might be one. That's what
We're all-
I want to say we've always been really reluctant to.
No, I-
There is, I apologize.
Yeah, yeah.
There's a different section that covers newspapers, that's right.
So I'm just,
So, and that's a similar, it's a similar.
I'm just, because I don't know the answer to it. Is there some sort of parity on the penalty between the?
Penalize the printer?
The maker of the ink.
What about somebody who prints my phone card?
Yeah, that's
We don't,
No requirement.
they're protected.
My other question is, the due diligence provision on the, each television or radio station provider shall establish due diligence policies, procedures, and controls, so that they have to establish the policy, right? And is that, do they have to file that anywhere, or is it, that's just something that's we'll looked at retrospectively if there's
Right.
a violation?
Correct.
Although, did you have
Yeah,
appropriate?
I think the way it would work in practice is somebody would come to the commission with a complaint. This media company published this
Yeah.
illegal ad. We don't think they had a policy in place, and the commission would ask them, what's your policy?
And that would be considered in
But there's-
assessing their,
But that's the same.
Regarding the fine,
Rule.
right.
and I don't know what the ceiling should be at this point, but would it make sense to simply say shall not exceed $5,000 or should
Everyone
not
knows
exceed?
about the safe harbor.
I think
Yeah, I was just wondering if that should.
I'm agreeing that maybe unintentionally, even flagging the 100, the way it's structured grammatically kind of says, yep,
You certainly could do that. I mean, I guess the issue is that, the main thrust of this statute is to prohibit these foreign government influence entities from being involved in Maine elections.
Right.
So they're kind of the target of the statute.
right,
And it's 5,000 if they violate the statute on the civil side. So the question is just, should the media media companies have sort of an equal responsibility there in terms of maximum fine, or should there be some leniency given that they're regulated under this statute as sort of a secondary way to prevent the foreign government influence entities from being able to influence elections. So they're not sort of the primary focus of the statute. And that was sort of the idea that, perhaps they should be treated differently than the foreign government entities that are really the target of the law.
but the interface is generally at the media level with the public. When I think of certain radio stations, for example, and I'm showing my own bias in saying this, but it's the money that's behind the personalities that are on mic that are saying and managing certain segments of a show that get very unilaterally political. That's where that matters. That's where the public relates to this. And I think that I'm just thinking of an ongoing dialogue I'm having with a friend of mine who happens to be a host on a radio station with which I vehemently disagree 90% of what he does. But that's where the public gets involved in this. And I think that the station or the newspaper or whatever needs a heightened awareness of any connection like that. So I'm just wrestling with this. How do you tier it? How do you separate those factors compared to the actual legislation that was approved while we're all waiting for that to be contested?
One factor that was weighing on me was that some of these cable systems that sell advertising, they could be national companies, and they wouldn't, it's very hard for them to know what the
Rules are.
to have a due diligence policy relating to Maine. And so maybe for one unintentional violation, the commission would show some things.
oh, sorry.
Agenda, that's all.
I agree with that, and I think that we would, but I hate that it's $100 max. That's just such a low amount.
Yeah,
It's
yeah.
a very low amount at this stage.
It just seems like it's ineffectual. What would be a better? So low it's
Well, I mean, even
That
if it's a $500 maximum, and most of the time, we're gonna reduce it to $100. We have this now, right? We have sort of standards, and if it's not, I don't know, but $100 maximum seems like That's, you know.
Gonna spend that on
You
lunch.
know, and I imagine this coming up, right, and how, you know, it depends how often it was broadcast unknowingly, it will depend, and it's, if all we can do is $100. There's also, I would prefer a greater max penalty, but then I think you take these things into account.
Right.
It was one national broadcaster that had one ad, yeah, maybe it's
Right.
a $50 fine.
But I can say that in working with Jonathan, there's nothing magic about $100.
Yeah.
It's just a number we came up with. So I don't have any concerns about a different amount.
I'm also wondering, are we confusing standards here? We're saying, knowingly in the rule, and the statute says intentionally.
Yeah.
In the penalty paragraph 8. The knowingly standard is in the violation, the criminal violation.
Not very good.
Yeah, I don't think it, because I think you have rulemaking, your rulemaking powers include the ability to sort of operationalize these standards. I don't think it's necessarily a problem to have a different standard for the $100, for this $100 threshold, because it's kind of an idiosyncrasy that you're putting into the rules, but you certainly could change it to intention. If you wanted to do that for consistency, I guess I agree, it would sort of be more streamlined with the statute in that regard.
I think I would leave this out entirely. This secondary, level of fine. I think the commission is gonna be able to handle setting the fine for whatever the circumstances. I don't think we need to set a ceiling, whatever it is, $100, $500, $1,000 on unknowing violation. I think we can figure that out.
Now they do that now.
Yeah, we do that all the time.
Yeah,
So I'm just trying to understand this, and I don't think I do, but, section 9 refers to as class C crime,
Yes,
and I'm assuming that a broadcaster is subject.
no,
No.
the criminal aspect of this law is limited to foreign government entities and, individual. I suppose, if you've had somebody who is providing substantial assistance, that sort of stuff, but the section that details the media obligations is not covered by the criminal aspect of the
so yeah,
statute.
section 2,
Right.
Okay, I
Good question.
clearly need to read this more carefully, so. I guess, hypothetically, it's possible. I mean, how do you enforce? I'm trying to, I know we have the Canadian issue, which is probably pretty tameable, accessible entities to draw into this. But it's possible that there would be other entities, foreign entities that we're not gonna have any impact on. Possibly.
You mean where we wouldn't be able to enforce the statute against them because it's a foreign government and,
Yeah.
another part of the world?
Yeah.
Certainly, I think there are probably, if you have a foreign government officials in another country, directly purchasing advertisements, there may be challenges with enforcing the statute, but I think the way it often works, right, is that there's an intermediary, right, and the
Right.
intermediary could have liability. That
They would be
could
subject
a target
to the-
of enforcement. I think the foreign governments are, under the language of the statute, a foreign government is subject to this. So it's not that it doesn't apply to a foreign government, it's just that enforcement would be challenged.
Yeah. Right. Yeah.
But the entities that they might use to bring the money in would also be subject to the criminal penalty.
Yeah, and there are these provisions about, providing substantial assistance, in making one of these contributions or a structuring transaction, so there are ways it's sort of, the statute covers sort of everyone who's involved, and at least, knowingly, intentionally involved in making one of these transactions, is covered.
I think personally, I would prefer to leave out this paragraph,
Which paragraph?
the one called enforcement on paragraph or on page 3. It sets up
Oh, yeah.
the second tier of penalty.
It does confuse it a bit.
Yeah, I think we can handle, and I think having the potential for a greater penalty makes it more likely that it's compliant.
What about the $5,000 penalty? Is that,
That's in statute.
That's
that's in
That's
statute?
a statute, correct?
Yeah, so I'm sure to make that.
Yeah.
Because I would have probably have gone higher.
Have these been
Well,
posted
it's
yet?
$5,000 or double the amount of the contribution.
No, you have, I mean, they're posted on the Ethics Commission
But as
website
it's-
because we
Right.
provided them to you for this
Yeah.
meeting, but they have not, you have to vote to
To,
initiate the rulemaking
so can
process.
we change
You can.
these today?
How do you feel about the elimination of that paragraph that's suggested?
I think, you know, it's really up to the commission. You know, the idea was to sort of show in the rules that, you know, there will be some sort of leniency applied with a new, you know, new requirement that media companies aren't used to being subject to. But I think you can also, you know, apply your discretion on a, you know, on a case by case basis, which you obviously do, in all sorts of matters. So,
We're very discreet.
of course, yeah. So, you know,
Is this, unusual? For example, that we just had that matter with the $5,000 fine, and it was noted in the papers that, you know, for the first couple of years, the commission was a little bit more lenient, but now it's been a while. I mean, so it seems like we do that without it being written down. I don't want to have this rulemaking be a little bit different, and then maybe that means with another statute doesn't have this kind of provision where we shouldn't be
Mhm.
giving that leniency.
No, those are good considerations.
Yeah, so I'm leaning towards keeping it out, but I think that we would, just like we do with other statutes. consider
Yeah,
that
I-
in the law.
again, I think the reasoning is that the media entities are sort of one step removed from the real target of the statute.
Although they are the gate.
I was just gonna use that
Yes.
term, they are the gatekeepers. Mr. Wayne, do you want to advocate for or against?
No, I agree with that.
Okay.
I mean, just thinking aloud, I don't know that but we could say something like, you know, the commission may consider the fact that a media provider, the violation wasn't knowing, or sure, put that in there, just so
As a
folks
disclaimer.
know, as a disclaimer, and if there's future commissioners on.
Yeah,
to
provide
handle
some
it.
guidance.
Yeah, and so it doesn't give it provides some guidance, doesn't give a maximum, but
Yeah.
lets the public know that we're not so cold-hearted.
Some of us are cold-hearted. I think that's a good idea. Maybe I'd amend this enforcement paragraph to say, yeah, something like, you know, the commission can consider, the mens rea of the media company.
We always do.
Right, we did.
I know, I mean, as I'm thinking about it, I just
Right, it's
also,
gonna challenge it.
going back on what I said, because we think, we'll consider that, we'll consider if it's a first time violation, we'll consider where the company's from, we'll consider the amount, you know, the number of ads that
It's not a
were
mechanical
distributed.
thing. It's.
Yeah, and so I also, as I'm saying that, I would make it included but not limited to, so then I think maybe we just shouldn't put that in, because those are all things that we can.
Mr. Clardy included that in his opening statement
Which were,
about how we operate subjectively and use these factors and.
but our, Mr. Bolton and Mr. Wayne both support this. Being very polite about it.
Maybe we've been too comfortable for a few years. Maybe we should try to shake things up a little. I don't know.
It's really, I don't have concerns about whichever direction the commission wants to go with this.
We don't need a motion or anything, right? Or
I
do
think
we?
you can just sort of direct staff what you.
Yeah.
I think if you're,
agree with you, I think.
I guess, well, the one thing I would say, it depends on how you want to go about this. If you're looking to start the rulemaking process today,
I
you
think
probably would want to direct him in a formal motion to make this change and then start the rulemaking.
Yeah, I think we are not.
Yeah, I think take it out, we'll look at it again.
Yeah, I think take it out, we'll look at it again. Yep.
Okay. So we'll be hearing next month.
Right.
Things out of litigation, I don't think there's any rush.
Correct. Exactly.
John, can you
if-
tell us what
if-
you're, tell us what you're. I just hear you, I mean,
Well, I guess, so the only thing to think about is that, you know, having these rules sort of moving through the process could sort of intersect with the litigation you know, in terms of looking at how these terms would actually be operationalized. You know, the court might find that of interest. Obviously, there won't be anything final until the whole process is final. So there might be some value to moving this along if there's something discrete, that there's just one discrete change that you're comfortable with, that we could make and start the process, we could work that out. But I think it's, you know, I don't have major concerns if you feel like you'd rather not hammer out exact language right now and wait a month.
remind me what it means to start the process. I mean,
So
what does that?
there'll be a note of the Secretary of State, you know, we'll send a packet to the Secretary of State. We'll formally sort of announce that the rulemaking process has started. There'll be a public comment date, you know, deadline for public comments. And then, you know, once that's all done, you'll get the public comments back. You'll consider whether you want to make any changes to the rule and then vote on final adoption. So,
Why not start it?
Sure.
Okay.
Okay. So,
So what do we decide?
I think we decided.
I just nodded, yes.
I'll make a
What do I
motion.
agree to?
I'll make a motion then that we proceed to rulemaking. And we enter into the rulemaking process with the rules as printed, except amended by elimination of the enforcement paragraph.
Second.
There's a second. Is there further discussion? No. Okay, all in favor, please say aye.
Aye.
All opposed, please say no. All right, we'll enter into rulemaking. Other business, Mr. Wayne.
Sure, I wanted to make the commission aware of some correspondence we received. This was from State Representative Michael Sobolewski, who had concerns about a decision by the Secretary of State. She made a decision about the nominating petitions of Donald Trump to be on the ballot this year, and
Some of you may have heard of it.
Yeah.
and Representative Sobolewski was concerned about potential bias by the secretary. He wrote us a letter, he asked to be heard on this. But I conferred with the council and about what our jurisdiction is, and we are only ethics jurisdiction in terms of official misconduct or official bias related to legislators. It doesn't relate to the constitutional officers, and we don't have any jurisdiction over federal elections. So I wrote him back saying, we're sorry, this is not in our jurisdiction.
And our rules provide for that. After you've consulted with counsel to write a letter, just as you've done, to explain that. So,
Right. We followed the letter of the rule.
and
And then you're supposed
Yes.
to tell us.
right, exactly.
if I could just clarify one thing, he consulted with another AAG about this matter because I represent the Secretary of State.
Right.
Just generally.
Right.
It all makes
So the legal advice is sus.
I think we've addressed that potential issue.
Terrific. Is there anything else we ought to deal with? Anybody want to make the motion that never fails? Is there a second? Oh, it failed for lack of a second. Oh, well.
Talk about it.
second.
Okay, and it's not debatable, so all in favor, please say aye.
Aye.
All opposed, please say no. Thank you, folks. That was a great meeting.